And we'll begin the questions with the Deputy Chair of the Committee, Senator Baker.
Thank you, Mr. Chairman, and we thank both the witnesses, Mr. Thomas and Mr. Wiseman, for their appearance and their words of wisdom to this committee. I'll ask one question to each of the witnesses. Mr. Thomas first. Mr. Thomas, you've suggested that the bill be altered, this new legislation, to allow for the retention of records relating to robocalls or any similar matter be retained for 5 years instead of 1 year under the present bill that we have before us. Upon reconsideration of that, wouldn't you agree that 10 years would be more logical, given that the Elections Act, the provision of prosecution in the Elections Act for a summary conviction offense, not even an indictable offense, the charges can be laid 10 years after the occurrence of the event. So wouldn't it seem more logical for you to revise your suggestion from 5 years to make it 10 years to comply with the provisions of the present Elections Act?
I'm not a lawyer, so I have to be careful of what I claim to know about this, but I know that in the United States, they've been wrestling with the problem of so-called robocalls, and I'm actually trying to write something about that currently. And they've made it a requirement, a number of different procedural requirements and then record-keeping requirements, and that has sort of been the average period of time is 5 years. I presume that industry representatives would claim to keep records around beyond a certain period of time is not cost efficient or whatever, although in the digital era one wonders whether there's much expense associated with that. I guess you'd also look at what happens when there are investigations leading to prosecutions and court cases and the way those things drag out in the Canadian context. In all the attempts to amend election laws, we're always trying to balance effective enforcement and compliance with due process and the rights of those individuals and organizations that are accused. So you presumably don't want it to linger out there too long, because during that period, presumably a worthy candidate or a party organization is under a cloud of shame, so to speak. So you've got to find the right balance. It's like baby's porridge, not too hot and not too cold. You've got to get it just right. You may be right, I may be too cold.
Yeah, no. This committee, Mr. Thomas, dealt with this question when this government first came in under the big bill that they brought in, as to whether or not we should extend it to 10 years, which it was extended for 10 years for the bringing of a summary or indictable offense. Because as you know, under the criminal code, it's 6 months for a summary conviction offense, because you don't want there be a too long period. So my question to Mr. Wiseman is this. Mr. Wiseman, you made a statement. You told us that vouching does not resonate with the public. And then you went on to elaborate on it. It may not resonate with the public, but it resonates with the courts. If you go back to every single court case involving the Elections Act and somebody claiming they were denied the right to vote because of our changes we brought in 2007, 1997 as well, all of them. Section 3 of the Charter says that every citizen has a right to vote in a federal and provincial election campaign. Mm-hmm. So any restriction on that, any requirement of identification, has been judged by our courts to be in violation of Section 3 of the Charter. So then the court moves on to Section 1. And they do an evaluation. Do the salutary effects of the legislation outweigh the deleterious effects of the legislation? And that's the measurement that's done under Section 1, the Oakes test that my friend referred to in a previous. Now, we have heard from the Chief Electoral Officer what the deleterious effects are. He says tens of thousands of Canadians will be denied the right to vote. So I'm wondering how somebody could come up with salutary effects that would outweigh such strong deleterious effects that the Chief Election Officer has put himself on the record in this committee as stating which can be used in a court of law as evidence unless the leadership in the Senate says this is all under parliamentary privilege and it can't be used, Senator Cowan. Mr. Wiseman.
Thank you. Well, I respect the courts, but have disagreed with a lot of their positions, including how many people can constitute a party. You know, for them, there's no limit.
You mean the Figueroa decision?
Yeah, the decision. You know, it used to be 12.
Yeah, of course.
And they said, no, we can't have any. I disagreed with that. Okay, but I accept the court's ruling. They've ruled what they have. You're making an assumption, Senator Baker, with respect, which is that all the people that are being vouched for are people that could not provide identification. I believe in many cases it's a husband and a wife, and they know that, yeah, you've got ID, you don't have it on you, I'll vouch for you, it's not an issue. So I don't even know the exact numbers of people who haven't, I've heard 100,000, I've heard 120,000, I believe it's in that range, I don't dispute it, but I do dispute that in all those cases it was because they never had identification that couldn't be used. I also support, I think it's reasonable to have to provide some ID. The Constitution does say you have to be a citizen. You don't have to prove you're a citizen to vote. You just have to provide identification. And a lot of people that have driver's licenses, I notice Elections Canada gets their list from motor vehicle branches. Yeah, they have a driver's license. They may not be citizens. They shouldn't be entitled to vote. I'm not even saying, but I'm not saying that they should be providing citizenship papers. I have said that I think the voter identification card, despite the limitations with it, should be kept as a form of identification. That would facilitate. I don't think that should be dropped. I heard, I've only caught bits of testimony. Sheila Fraser mentioned that her daughter, who's a university student, would not be able to vote. And then I thought to myself, well, because the university just communicates with her on the internet. And I thought, well, doesn't her daughter pay for her internet provider? Doesn't she get an invoice even if it's online with the address? When you register at the university, there's a record. You have to have an address. That would establish where the person lives. So I think a lot of these problems exist in theory. I admit there will be a few people also, I think, on Indian reserves. I think with your Indian card with the photo ID and a letter from an administrator there, a blanket letter going to everybody that you live on this reserve, that my understanding is you would qualify as one of the conditions. Similarly in seniors' homes, where I noticed Mr. Mayron said, well, some administrators in senior homes don't have the resources to produce letters indicating that this person lives here or refuse to do so. Yeah. Well, compel them to do so. We now compel landlords to allow partisan canvassers to come knocking on my condominium door.
So, but that's another matter, though. That would be if we had that legislation there. If this is what we were doing, compelling them to produce the fact. The fact of the matter is that that there is no compelling as you've outlined, and the fact of the matter is that a great many seniors have all the mail come to one name at one address. And the fact of the matter is the chief electoral officer said tens of thousands, 120,000 he estimated, he didn't, he said tens of thousands, but the point being that the chief electoral officer is the respondent in the next application brought by a person that says, you've denied me a right to vote, and here's my name, here's what you see on the face of the case. And their respondent is the chief electoral officer. Well, the chief electoral officer has already said, yes, tens of thousands of people. Never before have we seen this where the chief electoral officer has been agreeing with the applicant. So obviously, the matter would be ruled unconstitutional, don't you think?
Yeah, it might be. I'm not a lawyer. I suspect from what you've told me, it will be. So the onus is on parliamentarians to fix the law so that people do have identification. You said all this mail goes to one person. I don't understand why this person who receives mail on behalf of others cannot be
Vouch for
compelled.
somebody.
That's right, or vouch for
They
them.
can't vouch.
Yeah.
You both made that point. You both made an excellent point on the